Welcome to this free immigration help channel. Today is March 18, 2023, and we are getting into the volume 34 of me going through all your comments and answering your immigration related question. Before I begin, I'm going to mention, as always, I'm not an immigration attorney. This is not a legal advice. All the information that I provide on my videos on this channel are directly from official government sources like USCIS and the Department of State. Also, I wanted to say thank you very much for the sponsor of this channel. Your sponsorship, it helps me make this channel better and more accessible for other people. Right now, currently what I'm doing is I started hiring people to translate some of the subtitles for some of the most popular videos, some of the most watched videos, and eventually I want to basically just translate everything to as many different languages as possible. You can sponsor this channel for as low as $1 a month, and it really does help. It really does help because I'm able to basically give more with this channel. So without further ado, let's start with the very first comment from J Boss. Thank you for the steps, big help, you're very welcome. Just a quick question in the section, where have you lived during the last 5 years? If I lived outside the US, for example in Russia or China, where they don't use Roman letters, would I have to put the address in the original language or in English? Great question, J Boss. Thank you for bringing this up. For whoever is watching this, I think this is going to be helpful. So whenever it comes to all of the information in the applications that you're providing, even if it's from another country, you want to put it in English, all right? Make sure to put it in English alphabet. Now, there will be, in some cases, some of the applications, not all of them, but some of the applications, some of the petitions, they actually do have specific wording that we want you to enter this information in your native language. Only when they ask you to put it in the native language, you're going to use your native language from whatever country it is. You know, for example, Chinese or Cyrillic, if it's, you know, Russian or Cyrillic, I think one of those. But you get the point. If the application specifically asks you to put it in the native language, then you do it. If not, then everything else is in English. So let me do this. And we're gonna move on to the next one from Manpad. How about son is divorced? Okay, so this question was asked on the alien relative petition I-130. So I'm assuming there's an I-130 that is in question, and somebody's inviting their son, and they were married, and now they're divorced. So if that's the case, I'm gonna because I don't know the details, I'm gonna assume that the son is over 21, and I mean most likely the case if they were married and already divorced, probably over 21. So if that is the case, all right, now your son is changing from one category to another. He's changing from F3 category to F1 category, and I actually have the visa bulletin from the Department of State open in front of me, so I'm going to show it again for whoever's watching. Is going to be helpful. This is the most recent visa bulletin for March 2023. April 2023 is going to be coming up very soon, so I'm going to make a video specifically on April 2023. But right now, if you want to watch the video that I've made on March 2023, you can check it out. It's called Understanding Visa Bulletin. It's uploaded on this channel. But currently, as you can see, married sons and daughters of US citizens, and I'm assuming you're a US citizen for the purpose of this video. If you're not, let me know in the comments below and I will address that. But this is the third priority category, which you see F3. And for F3, we're going to scroll down to the dates of filing graph because it's a little bit easier and more universal compared to the final action dates graph. Again, if you want to understand why, check out the video that I've done on Understanding Visa Bulletin. But right now for the F3 category, the visas are becoming available for those who filed back in November 2009. So there is from 2023, 2009, my math is horrible, so let me take some time and calculate this properly. You know what, in fact, how about I just grab a calculator? It's really bad. I can't think and talk at the same time. 2023 minus 2009. There's a 14-year delay. 14-year delay. And compared to the F1 category, which is what your son would be in, because now they're unmarried sons and daughters over 21. This is over 21. Both of these are over 21. I don't know why they didn't specify. It's very important, but they didn't specify it. You know, hopefully they will one day, but it is over 25. So F1 is 2016. So when 2016, 2023, 2016, there is what? Let's see, 7 years delay. So 7 compared to 14. That's a huge difference. That's 7 years difference. So that means that if you submit the request to the NVC or the USCIS, depending where the case is, and they update the category for your son, potentially they might save 7 years of waiting for that immigrant visa to be available. So to answer your question, make sure to submit the update. If the case is still with USCIS, then you want to notify USCIS. If you need to update NVC, National Visa Center, then you have to notify them to update that category. All right, let's move on to the next one. Next question from Merns Basic, and I'm very sorry if I'm mispronouncing your names. My mom left the United States 8 years ago, and she moved back to Europe. She never had a green card or US passport. She only had an I-94 and social security number. We came into the United States as refugees in 2001. She would like to come back. Is she allowed, and what are the steps? And there's read more. Let me read it. Thanks. Okay. So you're very welcome. Thank you for asking your question. So I'm assuming from your comment, it's not 100%, but I think your mom also came as a refugee, right? And correct me if I'm wrong. Also, I'm gonna mention, if you're following up to my answer in this video, make sure to submit a separate comment. Don't respond to your own comment within your own comment, because I don't get notifications for those. So please submit the separate comment. But for the purposes of my answer in this instance, I'm gonna assume that she also came as a refugee. Normally, it's not recommended. It's not a good idea to go back to the country where you came from if you had a refugee status or an asylee status, because basically that annuls it. It kind of contradicts completely the refugee or asylee status, because by refugee or asylee status definition, you are applying for that status based on the persecution in the country that you came from. So if you have it, if you got it, if you were granted it and you went back, basically you give up that status. You show that maybe you were not persecuted, maybe there wasn't really a threat. So it's a little bit of a problematic situation, because if your mom goes back to the embassy and asks for really whatever, I mean, everything will have to be from scratch. Whether it is just a regular non-immigrant visa to come down to the United States to visit you, or if you start a alien relative petition, I-130, for your mom, depending on which status you have. Like if you are a US citizen already, now you can invite your parents. You can petition for your parents. If you do that, still your mom eventually will have to go to the embassy for an interview, and regardless, they will raise that question. They will say, hey, you were in the United States and you had a refugee status in the United States, and then you abandoned that status and came back to the country where you ran away from. That makes no sense, and now you want to go back. So in your situation, I would definitely advise to reach out, try to find a good family immigration lawyer. And even if your mom just wants to come here just to visit on a regular non-immigrant visa, still I would recommend talking to the lawyer, because whenever it comes to refugee asylee statuses, abandonment, it creates a problem. It really does create a problem. Even if you already have a green card based on that status and you go back to the country where you came from, during their naturalization interview, you will have some serious questions, some serious issue that you'll have to deal with. Why did you go back? If you were asking for that status based on the persecution in your home country, why did you go back? So definitely try to find yourself a good immigration attorney. Most of the good immigration attorneys, they do offer free consultation, and I would recommend just doing 3, 4, 5 different free consultations with different immigration attorneys. Just get different opinions, because most likely in this situation, what you will have to do is you will have to do inadmissibility waiver. Basically, inadmissibility waiver kind of to explain the situation. I don't know the situation why she went back, but in this case, it seems like you will have to do some explaining in that inadmissibility waiver, showing good reasons why she had to go back and why she needs to come back to the United States now. All right, let's move on to the next question from Ivan Martinez. Ivan, by the way, thank you for being publicly subscribed. This is what this icon means. I really, really appreciate it. Can you tell me what to do if there's no way to prove taxes? Which is, it's one of the most important things. It is. Whenever it comes to I-130, not as a part of the USCIS, but once your case is already transferred to the NVC, because NVC is now trying to establish, because USCIS, they, for the most part, they try to establish their relationship with the person, right? They try to establish, do you really have, is there really your mother or father or your spouse that you're inviting? Is the relationship real with your spouse? It's not fictitious marriage or anything like that, right? But once it transfers to the NVC, now all of that already taken care of. Now the NVC part, they're trying to establish if you really are sufficient enough to sponsor whoever it is coming to the United States, right? So are you enough of a sponsor? And if you are not enough of a sponsor, then you will have to have a joint sponsor. Now, whoever the petitioner is, regardless whether they like it or not, whether they have enough money or not, right off the bat, they will have to submit their financial information. And whenever it comes to the financial information, we're talking about taxes. And for someone who is petitioning for another person, you have to be permanent resident to invite your spouse, kids. You have to be U.S. citizen to invite your parents, your siblings, obviously spouse, kids as well. In either or, permanent resident or U.S. citizen, you've been living in the United States for at least 5 years now, all right? In that situation, well, if you're a permanent resident, for at least a year, year and a half, 2 years, right? You've been living in the United States. In that period of time, you have to have your files, your taxes filed. It's very important. Whether you make income, whether you really don't make income, you still have to show the IRS. And I know. I don't want to sound like, someone who enjoys this bureaucracy. Trust me, I'm not a fan of it at all. This system is, I don't agree with it. Let's just say that. But if you want to bring your family here, if you want to start this petition, then you have to participate in this bureaucracy. It's just part of the game. And having taxes, having tax returns, having tax transcripts is just part of this bureaucracy. You have to deal with it. So in your situation, if you don't have that, you will have to reach out to a CPA. So most likely what will have to happen is that you will work with an accountant, right? They will advise you on how to submit those taxes back, a couple years ago, because it is doable. It is possible. Make sure that what needs to be filed, obviously there will be some fees, some late fees that you will have to pay. You'll have to deal with that. That's just part of the process. So in your situation, I would definitely recommend to reaching out to a CPA, to an accountant, somebody who deals with taxes. Usually I recommend doing it yourself. You can use free services like TurboTax to file your taxes. But because you have some late stuff, you definitely want to do this with someone who has experience, who has knowledge, who's been doing it for a while, and tell them, hey, I need to show my tax returns for purposes of immigration, right? Immigration purposes. And I haven't been filing taxes, and I need to show taxes for the past 2 years. I need help. I need help filing the taxes that I didn't. And they will be able to guide you. So I'm going to do this, and we're going to move on to the next question. And for everyone whose question I answered, if you have any follow-up questions, you're more than welcome. Just make sure to don't answer within your comment. Submit a separate comment, because if you do answer within your comment, I don't get those notifications for whatever reason. I don't know why. Okay, moving further to Distraction World. Question: Sir, my petition still pending since 2019. Okay, so the question was asked on I-130. That is a petition for alien relative. So whenever it comes to I-130, whenever you're filing I-130, like I said, there are two steps, two big processes. And 2 steps, it sounds too simple. 2 big separate processes, all right? There's a process with USCIS There's a process when the NVC. There's also U.S. Embassy, but that's a whole other whatever. There's a little bit of waiting there, but not as much. So whenever it comes to the USCIS, depending on which category, and I'm gonna use this as an opportunity to do some navigation on USCIS, official U.S. Citizenship and Immigration Services government website .gov. Always make sure you get the information from official government websites, not the private attorney websites, not the forums. I'm not saying that they have bad information or something wrong, but whenever it comes to updated information, it's USCIS, all right? So we're going to go to Tools, and then we're going to go to Case Status Online, and that's where you can check your case status. You can enter your receipt number that you received. Your case have been obviously already accepted in 2019, so you will enter the receipt number, and it will tell you where your case is. But we're going to go to US processing times information. And I'm going to show you a few different categories because you didn't specify which category you're in. But let's say, obviously this is a petition for alien relative, I-130, but you will see there's a few different categories for US citizens. There's a few different categories for permanent residents. So let's say if you're a permanent resident inviting a spouse, there's a few different service centers depending on where you sent it. Processing time, 20 months. So let's say you're filing a petition for alien relative, and in your case you're a permanent resident and you're filing for a spouse or a child under 21, and you sent it to, your petition went to the Texas Service Center because you are in a state which jurisdiction falls for the Texas Service Center. 20 months processing time for USCIS only. So within those 20 months, your petition gets approved by USCIS, let's say. It is then transferred to the NVC. On the NVC, there's a whole other the whole other process that you have to take care of, showing the financial documents, and then obviously availability of the immigrant visa. If you're a permanent resident inviting the spouse or a child under 21, there is no visa cap, so it's going to be pretty good. But if there is a visa cap, now you have to deal with the visa bulletin. For different categories, there's a certain weight, there's a certain backlog. So if you want more details, provide more details for me, the category, where it was sent, which service center, and I would be able to provide a little bit more details. But you see how many different wait times are involved. Depending on which category you're in, depending on which service center, it can be different. So let me know more details if you want to, a little bit of a better estimate, and I will be able to provide more details. All right, moving further to 2009 Grasmere. Thank you very much for answering my question. Nice work, sir. Thank you, sir, for asking. Without your questions, this videos would not be possible. So all thanks to you for watching the videos, for asking the questions, for posting the comments. Even if you don't have a question, if you just say that it was helpful, it means a lot to me. I don't just skip over that kind of stuff. It really does mean a lot to me because it shows that the work that I'm putting into this channel is actually helping someone, and that's what it's all about. All right, let's move on to the next one from Curly Dog. It's been almost 3 months. When will it come on the internet? The job authorization says 3 months. Okay, so that was a question on the IA-21 application for temporary protected status. So if you do have a temporary protected status, you're also eligible for the employment authorization. You're also you're able to legally work in the United States of America. And yes, it says that within 3 months it should be processed. And you've been almost 3 months. Usually, whenever it comes to dates, whenever it comes to wait times for certain things, usually USCIS gives us 80% of cases are processed within 3 months. All right, so the 3 months unfortunately is not guaranteed, so it might be 20%. It still might be a little bit faster, it still might be a little bit slower. And I say, with stuff like this, give them 10%, okay, of the wait time. So let's say if the wait time is 3 months, right, the 10% of 3 months is going to be what? So 3 months. Why am I doing this math problems for myself? I have no idea. But let's say 10% of 3 months is 2 weeks, all right? Do the calculation for me. I'm horrible with math. That's why I went to law, okay? That's why I studied law and not math, because I'm horrible with math. But if you take off 10% of 3 months and add it, let's say it's 2 weeks, 3 months and 2 weeks, that would be more accurate estimation for a wait time, because they give you 80% of cases, not 100% of cases are processed in 3 months. So I would say wait about 3 months and a half, and then if nothing happens, then go ahead and submit the case inquiry. And if you are interested how to do the case inquiry, I've actually done a separate video specifically on submitting that case inquiry with USCIS. So it's uploaded on this channel, but right now you don't have to worry about. I know it sucks to wait. I completely understand it. I've been there myself. In fact, my EAD clock, it got there was a decision on my case like 3 days before my EAD clock was supposed to hit that full amount, right, where I could apply for employment authorization. So like 3 days, I didn't get enough to become eligible to work in the United States, and then I had to wait another like a year because there was a decision made on my case. It happens. It's part of it, and it's good to have patience. It's good to have your own peace and just say, hey, if things worked out this way, then God wanted things to work out this way. So I'll just be patient and I'll just deal with whatever is in front of me. If I didn't get it now, then I was not supposed to get it now. It's just part of the process. And really for me, it was a huge learning process, because it taught me how to navigate better within the law, finding different avenues and submitting those, expedited requests, and reaching out to senators and reaching out to other elected officials, and just trying to make things work. And I did make it work through these different avenues. I didn't have to wait the whole year, and however I got it sooner, and that gave me ability, obviously, knowledge and experience. So now I can share it with other people. So things always work out for the best, no matter how bad they might seem. It sucks to be in the moment and experience that, part of the bureaucracy, part of the system, but nevertheless you can make it work for yourself eventually. All right, so just keep your head up, and all I can do is just recommend being patient, and if times go over, submitting the case inquiries, submitting the expedited request, reaching out for help to, elected officials, senators, and so forth. All right, let's move on to the next one from Oboira Rhoda. God bless you, sir. God bless you. Thank you. My husband is in USA, and I and my son is in Nigeria. We already qualify. Our case is in NVC since January 15. I'm assuming January 15 of 2023. Still waiting for interview. Okay, Oboira. So looks like everything. Obiora, I think I said Oboira. Obiora, and I hope I'm pronouncing it correctly. I think everything is looking great on your case. If you were already documentarily qualified with NVC on January 15th, there is no visa cap for spouses, and I'm assuming your son is under 21, unmarried. There is no visa caps. So now the only thing that is left is for NVC, and I'm sure they already, from January 15 up until now, they usually have to do it within 30 days. So I think around, even before February 15th, they already sent your case to your local US Embassy. So your local US Embassy, they already have this case. Now it's all about just the scheduling. So literally anytime now you should receive your appointment. Usually the appointment is scheduled 1 month ahead, so you have the whole month to do the medical examination, to go through all the medical stuff, which again, I say it like I'm excited about it. I'm not excited about it at all. I think it's silly, but whatever, this is a whole different conversation. But I would recommend getting this medical examination done as soon as you get notified about the interview, right? So you get the notification of the interview, go ahead and do it like within the first week. Don't wait until closer to the interview to do that medical examination. Why? Because doctors, they have to transfer some information to the whoever's doing the interview, the consul in the US Embassy. So when you go for an interview, you want them to already have all that information. So that's really only advice that I can give you on your case. I think everything is looking good. Literally anytime now you will be getting your interview scheduled with the US Embassy. Alright, moving further to Smira. Some love from Smira. Thank you very much for watching, and thank you very much for the love. It means a lot. Again, it shows me that, you know, the work that I'm putting into this channel is, you know, not in vain. Next question is from Anar Musayev. Thanks for your answer. You're very welcome, Anar. Thank you for watching. I know right now need to wait 365 days, and after you can apply for EAD. And I also try expedite my case. They have criteria and they also ask a proof. Only way is it's a hire a lawyer who asks $6,000 and they really can expedite case. I don't know how, but why I need pay this money. System is broken and nothing works for me. I just wait for my life is moved forward with hope and wait. Anar, sorry you're going through this. It's, you know, sometimes I've been there. I know exactly how it feels, and you probably just heard me telling my story if you watch the whole video. I've been there. I know exactly how it feels, and it feels very, very bad because you're here, you're in the United States, you're doing everything right, all right? You're paying all the fees for the application, and yet you can't work legally, and you're just in this limbo, just waiting for something, not knowing what. You can't rent an apartment, you can't go and get a normal job. It sucks. I definitely understand why. One thing that I wanted to ask, which status are you referring to? Which status are you in? And why is it 365 days? Because 365 days for EAD, right out of, from what I have, the experience, the knowledge, I don't know of any status that requires you to wait 365 days to get your employment authorization document. All right? Asylum is 150, 180 days whenever it comes to the EAD. Temporary protected status, once you get it, you get the EAD. Whenever it comes to immigrant visas, once you come on the immigrant visa, you have the temporary step I-551, I think, or 551, I'm pretty sure. Temporary permanent resident card, which is already serves as an employment authorization document. So you can already work legally in the United States. So let me know which status you're referring to, because I don't know of anything that requires you to wait the whole year to apply for the employment authorization. That just doesn't sound right. So again, you're talking about hiring a lawyer, so you talked with a lawyer, I guess. Maybe the lawyer misinformed you. And I know it might sound like a surprise to a lot of people, but I've personally, myself, have been scammed by an immigration lawyer. Scammed out of $10,000. I was, myself personally, scammed by an immigration attorney out of $10,000. So it happens, you know. It's people, you know, people want to make money, and people who are obsessed money, the more they depend on money, the more they're obsessed with money, the more likely they do bad stuff like this to other people without any kind of remorse. And you know, immigration attorneys, they get in, you know, they pay all these crazy fees for their law schools, right? Law schools are extremely expensive. And then they pay all these fees to get their bar exams, all this licensing, all this stuff. They, you know, go and then they work for pennies for a big attorney firms. And if they want to start their own practice, they have to go and they have to, you know, rent a space and all that sort of stuff. So they are already invested. So now they want to get a return on their investment. So of course, whenever it comes to an opportunity to make money, they're not going to pass that opportunity to make money. They will tell you, oh yeah, you'll have to wait the whole year unless you hire me for $6,000 and I will help you do that. Here's the thing though, Anar, and for everyone who's watching this. Whenever it comes to an immigration attorney, for the most part, 99% of stuff, what they can do, you can do yourself. Now, you might not know what they are doing, what avenues that they're using, but if you did know, if you did your research and you found out, you will be able to do it yourself. The only real thing that attorneys, they give you kind of an advantage is whenever it comes to the court proceedings. Because if you do go to a court proceeding without an attorney, you will have to wait till the end of the line. Ask me how I know, because I've been there. I've been there myself. And I've been in the court waiting for 3 hours for a stupid master hearing that absolutely means nothing. They just ask you one question, you answer that question, and then they leave you. And then they just say, okay, you can go. That's it. You'll come back for individual hearing in the next 6 months. They made me wait, me, my spouse, my wife, and I think my daughter was like 3 or 4 months in the car seat, in the court. We were waiting for every single person that was waiting. And master hearings, if you know that there's a whole bunch of immigrants that just sit there and they call them one by one, and you just answer one question and then you leave. You answer, and if you don't show up, then your case is denied. So you have to show up. And I was sitting there for 2 or 3 hours with a baby, waiting. Why? Because I did not have an immigration attorney. Everybody else had an immigration attorney. So that's how messed up the system is. So I completely understand what you're talking about. So with that being said, everyone who's watching, you have to take responsibility for your own case. You have to be yourself as strong as you can be without relying on all these people. Because if you do, if Anar falls for it and says, you know what, I can't do anything without an immigration attorney, he's out of $6,000 already. Just like that, out of $6,000. And there's no guarantee that that attorney is not going to tell him like, hey, I've done that, but now we have to do this, and that's going to cost you additional money, because that's how it works. So I can definitely relate to everyone who's going through this, because I've been there myself. The best thing to do is do your research. Study as much as possible, and remember that everything an attorney can do, you can do. The only disadvantage you're going to have is actually in the court when there's a whole bunch of other people with attorneys and you don't have one. You will have to wait, because the judge does not see, because judge gives the priority to everyone who has an immigration attorney. And I actually walked up to the judge and I looked him in the eye and I said, hey, I'm here with a baby. You have one question for me. Can you give us, there's a baby here. And he said no. That's how the justice system is. It's trash. It's complete garbage. So trust me, I can relate. I can relate to all of this. All right, let's move on to the next one. From Monica Pierre. When will my case be current? F1 from 2015. Okay, let's take a look. We got the visa bulletin pulled up here. So F1 category is, like I said, unmarried sons and daughters of US citizens over 21. And currently the date of filing, the visas become available for people that have filed back in August 2016. And let's see, so you have filed, okay, so the case, when will the case be current? So from 2015, so you have filed in 2015, and right now they're processing stuff from 2016. So they're already 1 year ahead. So you should already be anytime now. You should be receiving, let me see, which months of 2015 was it? Was it like the end of the year 2015, or was it more of the beginning of the 2015? Because you are now definitely getting over, so the visa should already be available for your case, because as you can see, they're processing stuff from the 2016, and you have filed it in 2015. So I'm assuming maybe there was a delay in NVC processing. Have your case already been transferred to the NVC? Have you already been documentarily qualified with NVC? If you could let me know, please do, and I might be able to follow up and answer a little bit more details to your question, because from what you told me, it should already be available. Just please make sure to submit a separate comment. Don't respond to this right here, because I don't get notifications. I don't know why. I don't. Just put a separate comment and it will appear like this in this wall. All right, let's move on to our looks like last comment from Miriam Art. When you ask to translate, do you want on the main comment or on the individual's comment? Miriam, I cannot tell you how much I'm grateful for what you're doing. Miriam, I'm going to tell she is helping me with the translations from Spanish to English. I don't speak Spanish. It is really helpful. If you see comments in different language on this channel, you can post underneath that comment. So let's say right here, Jackie, and you see I saved Jackie here I did not do anything. I didn't put a like or a heart, because if I do, it disappears from my wall. So if you go ahead and respond to Jackie's comment, just responding to her with the translation, I will still see it on my wall because I have not responded to her. And I know it's really weird. I don't know why YouTube made it this way, but you can go ahead and submit under her comment the translation, and I will be able to see it and I will be able to address it. So Miriam, again, thank you. And I already answered way back from Mark. You see, it's from a month ago. I just have not put a heart on it. But thank you very much, Miriam, and thank you everyone who's watching, everyone who's asking the questions. Again, if you did not ask questions, I wouldn't be able to make these videos, you know. And you see how these videos, they slowly turn into kind of like a podcast, I guess, style, where it's not just I'm answering questions that are being asked, but also it's becoming helpful for other people who are watching these videos, because we're talking about different experience. We're talking about, you know, kind of like a immigrant community, and you know, it's just part of it. It's part of it. It's part of the process. You have to deal with the system. You have to deal with documentation. You have to deal with bureaucracy. You can partly give up that responsibility into someone's hands and let someone else handle it, but you're gonna be spending some money, and also it's not guaranteed. You're opening up potential for mistakes, because it's someone else doing it for you. All right, there's a difference. Whatever you are doing, you will always put in more effort, more care, more love, okay, into it, because it's you, it's your case. You care about it. When somebody else does it for you, they will never have that care, that love. I'm not saying that they're going to be reckless, but they're not going to have the same amount of care for this case. That's just part of it. So it's already 36 minutes of this video, a little too long. Thank you everyone for tuning in. Always appreciate it. Looking forward to further questions. As always, appreciate your time. God bless, and I will see you in the next video.